Good morning and welcome to another edition of Law Talks here on 4CRB. This morning we're looking at a situation that can catch families completely off guard at an already difficult time. When someone passes away, many families assume their will clearly set out what happens next. But what if the original will can't be found? Does that mean it was destroyed on purpose, or could it simply be lost? This issue has been thrown into the spotlight recently following a major court case involving a $24 million estate, where the absence of an original will led to years of legal dispute and significant emotional and financial cost for the family involved. Today, we're unpacking what the law assumes when wills go missing and what people can do now to avoid their loved ones facing the same uncertainty. And today we're joined by Attwood Marshall Lawyers, estate litigation partner Lucy McPherson. Thanks for joining us, Lucy.
Hi, Robyn. Thanks for having me back.
Well, Lucy, when someone dies and their original will can't be found, what does the law usually assume happened?
So there's what we as lawyers refer to as presumption of revocation by destruction. Now, that's a lot of legal words, but what that means is that the law presumes that a will has been destroyed if it cannot be found. So often as estate planning lawyers, we will counsel a client to retain their will in a very safe place, their original documents in a safe place. We, for instance, have a strong room where all of our original documents are held.
Okay.
Now, there's a very good reason for that, because the original will is required when you pass away in order to apply to the court for a grant of probate. Mm-hmm. Now, if you can't find the original will after the date of death, then the law assumes that the person has taken that will from the safe place with the intention of destroying it.
Okay. All right. So can you explain the presumption of revocation in its simplest terms?
So it ultimately means that there is a presumption that the will has been revoked because the will has been destroyed intentionally by the will maker. And
is there a case that you can talk about, you can tell us about what went wrong in this particular case?
So we often come up with this set of facts where, say, for instance, a will maker goes to see a solicitor, has a formal will made with a solicitor, but chooses or elects not to have the original documents stored in the solicitor's strong room or safe. Most solicitors do have strong rooms or safes in order to retain original documents.
Yes.
But sometimes clients will elect to take the will with them themselves.
And keep it in their own safe place.
That's right. Safe being the key word there. Now, what happens is if the client takes the will away and the will, for instance, becomes lost or cannot be found after the person passes away, then there is this automatic presumption that the person who made the will has destroyed it with the intention of revoking that document.
Okay. So is a copy of a will ever enough, or does the original will really matter?
Well, this presumption of revocation by destruction, just going back a moment, I'll lead into that question. It's not definitive in the sense that you can rebut the presumption with evidence. Okay. So whilst the law assumes that the will has been revoked by destruction, a party can rebut that presumption with evidence. And usually that evidence demonstrates that the person did not intend for that will to be revoked.
Okay.
Now, just moving on to your question about a copy, in those circumstances where you have really strong evidence that the will maker did not intend for that document to be revoked and intended for it to be operative, then you can apply to the court for a grant of probate of a copy of that will. Mm-hmm. So you would apply to the court to say, look, we can't find the original document, but we have really strong evidence to suggest that the deceased person, the will maker, intended this document to be operative. It may be, for instance, the form of evidence that may be quite compelling in that scenario is, for instance, a conversation on the deathbed about this document and that it was intended to be operative. That would be quite compelling evidence that the will maker didn't intend to revoke that document despite not being able to locate the original.
Why does safe storage of the will make such a difference?
I think the answer to that question is ultimately because none of us know when we're going to die. And even though we may have the best intentions with respect to the storage of our important documents, you might move house and misplace things or misplace boxes. It's really quite easy to misplace or lose important documents. And that's why safe storage of original documents, original legal documents, particularly wills, is so important. We strongly recommend to our clients that they instruct us to keep their original documents with us so that those original documents are easy to locate after the date of death. As I mentioned, often people will elect not to do that. But it's my view that that's, it's quite a risky practice to do that unless, you have your own safe at home, perhaps, for instance, and that you're telling people, where your original documents are. So there's not that risk of it being misplaced after you die.
Yeah. Now, Lucy, I know good practice is to update your will regularly, but for someone that's had their will for quite some time, they've left it with their lawyer in a strong storage. What happens if that lawyer retires or a law firm closes? How can people protect against that risk?
So what often happens when a lawyer retires or a firm closes is that sometimes law firms are bought out by larger firms or might merge into another firm, but contacting the law society in the jurisdiction where the firm was located is your best course to try and locate what happened to those documents. The law society should be keeping records of those things, so where the documents of the firm that closed are being transferred to. And sometimes the Law Society will retain those documents themselves.
Okay. Lucy, at a high level, what does it cost families emotionally and financially if a will is misplaced?
Well, it does make the process much more complicated for the reasons that we've discussed today, in the sense that because of this presumption that applies at law, that a will has been revoked by destruction, there is a need to address that presumption and address the presumption in a special application to the court that would ultimately otherwise not be required. So it does make the process more costly.
Yeah.
It does involve additional legal costs, and of course that inevitably involves more time than would otherwise be required.
Well, Lucy, thanks for your time today. And it is a great reminder that having a will is only part of the equation. Making sure it's properly stored and easily located can spare families stress, conflict and unnecessary expense. Thanks for joining us today.
Absolutely, no problem at all. Thank you.
You've been listening to Law Talks here on 4CRB, which you can hear every Friday morning from 9 o'clock.